I've walked into some really bad situations where there's elderly people living very isolated, alone in houses that are falling apart, a lot of deferred maintenance, super inappropriate. I probably should have called DHS and had some elderly abuse. I have not, but it was bad. Okay, so first of all, what made you choose to get into estate law and how did you end up working with seniors?
Yeah, so when I chose to take the bar exam, probably in 2009, 2010 sometime, during that process, I had met an attorney, Phyllis Pearson. She belonged to a solo practitioner networking group that just sort of informally met a couple times a month. So I began going to coffee with them. So after I passed the bar exam, I was like, well, I think I'm going to open up an office in Ankeny because I lived in Ankeny at the time. And Phyllis was like, well, why don't you just rent an office from me? So then I began working out of the office that we're currently still in West Des Moines. Phyllis did estate planning. She did elder law. She was doing many other things as well. But after we started working together, we sort of narrowed our practice areas and, she was already doing those things. I had a background in economics. My undergrad degree was in economics. And so the estate planning piece fit very nicely. Elder law, oddly enough, focuses a lot on math and reorganizing assets. So that came very easy to me as well. And so that's how I began practicing in those areas.
Yeah, everything feels like it just becomes organic when it feels right, or where you end up or explode. It's never something that feels like it's forced. So it feels like that was maybe the direction for you. Now, I do want to go back to how I actually came to you really quick. When I started getting into wanting to move in the direction of helping our seniors out, it was organic for me too, because my background is in social work. And then I, got into real estate. And then there were a lot of situations that pulled me in this direction of moving here. And so as I was researching things, it's kind of creepy how algorithms work. But every time I got on any of my social media, your workshops popped up. So it felt called to sign up. And so I went, and I was actually surprised because as a realtor, we have these first-time homebuyer events a lot. And it's great if you get one person there. You're excited. You had a packed house at that event. Let's talk about that for a little bit. You hold these workshops that are just free to the public in different spaces, and anybody can come. You can bring your parents, you can come alone, you can be 35 and come, but you do that just as kind of an intro level to let people know that you're out there. Do you do those often?
Each of the attorney just generally does one workshop a month. In the Metro Des Moines area, we do them all over. We do them in Ankeny. We do them in our own building in West Des Moines. I did one earlier this week at Stony Creek Lodge up in, I think it's in Urbandale or Johnston. We go down to Indianola. We go up to Marshalltown. And then obviously we do them in Cedar Rapids, Dubuque, Bettendorf. I do them up at Waterfront, up in Okoboji. So yeah, it's an informational event. We're trying to educate the public on, really just basic estate planning. We have those conversations of, hey, let's make sure you have all the correct documents in place. If you haven't been to an estate planning attorney in a decade, your documents are probably time to update them. We have that conversation of wills versus trust, which is the right plan for you and your family. And then we kind of briefly touch on this asset protection against long-term care costs. This aging population is super concerned about if I begin to need home care, or I move into assisted living, or I move into a nursing home, where are those funds going to come from? And so we talk about the legal aspects of how to best utilize things in those situations.
So after your workshop, which I will say it's like an hour, right? That's how long it was. You're scratching the surface.
Correct.
Right? Yeah. There's so much more. So the idea is that someone comes in, they meet you, you're very likable, you have enough information to say, here, this is what I can help you with. And then they make an appointment with you to come to your office and kind of break down their own, because when you're talking at these things, it's very general. You're not able to touch on, everybody has a different situation. You're not able to give anybody actual advice in those spaces when it's huge groups. It's just scratching the surface, correct?
Correct.
Okay, so I came into your...
Yeah, our firm generally does free initial consultations. So, we're happy to have you come in and review the documents you have in place and things like that.
Or the lack of documents that you don't have.
Or the lack of documents, yeah.
Right. So I scheduled the meeting with you, but it was to just ask the basic questions, the breakdown. And I remember you were talking, and I said, wait, Matt, you have to stop. I am a visual person. You've got to write something down for me so I understand this. So you went and got a piece of paper and you came back and you wrote it down for me. And I remember you slid the paper across the table and said, here, does this help? And I still have that piece of paper and I'll show it on here. But I don't know if it's just me, but absolutely nothing about any of that was like helpful. But that's kind of the problem is this is complicated stuff. It's not easy. You can't just go to AI at this point and figure this stuff out. You have to have a professional to protect you. And I guess that's the point of me wanting to introduce you here is there's no way for you to come on a podcast or do an hour session and tell people how to do it. Would you agree
Correct.
with that?
Ultimately, the estate planning documents are going to be unique to you and your family and your situation. Certainly there are, estate plans that you can get online and things like that. But it's really the advice that you're getting along the way that is helpful, that the local attorney can provide to you. And it's the execution of the documents. In Iowa, it requires two witnesses, and to have a self-proving affidavit, you need a notary there. So, it requires at least 3 additional people. And, wills are relatively inexpensive plans to set up, and to know that you're getting good advice and that you're getting the documents executed correctly. I think it's just a small investment to make sure things that are going to work out the way you want them to. Additionally, Iowa has went to a Uniform Power of Attorney Act back in 2014. Oftentimes those website legal forms do not look like the Iowa code legal forms. And so, when you take it into a bank, there's certainly going to be more scrutiny on those documents than if you're using a Iowa form. So I think there's just a lot of benefit of using somebody local, getting some good advice, and obviously getting the documents executed correctly.
And cost is always something that comes up. Even in the workshop, someone had asked about the difference in doing the wills versus the trust. And I think that you combated that well when they asked, wills are a lot cheaper than trust. But can you explain why maybe wills aren't the better option, even though they are cheaper?
Yeah, that is the will versus trust conversation. Just from a pure cost perspective, I look at it as, how much does the document cost to set up? So how much does the will cost to set up? How much does the trust cost to set up? And then the second piece of it is, ultimately at the point you pass away, what is the cost of administration? And so, generally wills are less expensive to set up. Trust costs a little bit more to set up. But then on the administration side, the idea or the goal is with trust, we're going to avoid the probate process and have the administration costs be less versus probate. So wills equal probate. And in that situation, the costs are statutorily defined, where the statutory maximum an attorney can charge is basically 2% of the gross estate value. So that would be everything in your estate except for life insurance. The executor can charge that same amount. And then the court cost number is a more narrow number. It's 0.2% of just the assets being controlled by the probate process. But again, just generally, fees are going to be higher in probate versus trust administration. I look at trust-based estate planning as you organizing things today to make it easier and less expensive to administer at the point you pass away.
That's a good point as far as like the cost side, but also the cost of your family. And I asked that on the basis of I think that some people think, or they say out loud, I've heard this, my kids can handle this after I'm gone. What is your response to that when it comes to what does it look like after both parents are gone and it's left for the kids to handle after they're gone? What does that do to the family? What are your conversations look like? What do the emotions look like? What does the dynamic do when the kids are now responsible, fighting? Can you speak on that?
Yeah, so you as the creator of this document, you're going to define who the person is in charge of administering your document. So in a will, that would be the executor. In a trust, that would be the successor trustee. So, you want to put a lot of thought into who you're naming as this person. Oftentimes it's one of the kids, but that role is going to be, they're going to be hiring an attorney to advise them. More than likely, there's going to be a CPA to do the tax returns. If there's real estate, there's going to be a realtor involved. They need to act in a conflict of interest-free attitude. They're going to have to prepare an inventory, going to have to prepare an accounting. So, the skill set for this person has to be pretty high. So if you don't have somebody in the family that can operate that way, that's when we would maybe look outside of the family and look to a bank trust department to act in that role of executor or act in that role of successor trustee. Hopefully
Who would
that
that
answers.
person be? Yeah, who but if you have to have someone outside and if they have all of this stuff created with you,
Uh-huh.
wouldn't you naturally be the person that the kids would be coming back to, or is that not always the case? Or who would this outside person be?
So the person that you name as the executor, the person you name as trustee, they're going to hire an attorney to advise them on how to get through the probate or trust administration process. Yeah, I mean, our binders obviously have our business card in them. We would certainly like them to come back to us. That doesn't always happen. That person, the executor or trustee, can choose whoever they want to. So when it's a family member, normally they end up back in our office. If we are looking outside of the family, I mean, banks literally have trust departments that all they do is act in the role of executor and successor trustee. So they're basically professional executors or professional trustees. And they know exactly what to do. And they're going to handle things in a fair manner, unbiased, and get things done very efficiently.
So would that be different than you? I guess I'm not quite understanding like why they would go to the bank and because you've already created the
Yep.
blueprint. And
So,
now
so
that bank professional follows the blueprint.
So I operate in the role of the estate attorney, so preparing the probate paperwork. But the role of executor is really the one responsible for doing all of the tasks associated with the distribution plan. So you're normally going to have an executor, which would be either a family member or a bank, and then you're going to have the estate attorney advising them on what to do.
And that would be in the circumstances that they have a trust, correct?
Whether you have a will or whether you have a trust, usually the person in charge is going to hire an attorney to advise them.
Okay. So, has there been a case, or what has been your worst case scenario? I know this has to stick in your mind of a mess. Just tell me about a mess that has happened of a family on either side that something wasn't in place, it was not written correctly. Is there a situation that sticks with you that this is your reason that I'm so passionate about this so this doesn't happen to another person?
I mean, usually the biggest issues we have is in the administration process, and it's when the person in charge, the executor or the trustee, operates with conflicts of interest. And so they are self-dealing. They're buying probate assets or trust assets at a reduced cost. They don't want to go get an appraisal. I mean, those are the biggest family fight issues that we see. But,
So, for example, do you mean, for example, like if there's real estate to sell and we have a farm situation and we've got 3 sons and now it's time to have to do something with the farm, we're getting that money or the value of the farm at a cheaper cost. So then son number one who gets first, gets to buy it, has it for a cheaper price and then he has less to pay out. Is that what you're talking about?
That's exactly what I'm talking about.
Okay.
Yep, that or, we've had situations where, there was a business involved and, there's lack of transparency as to what is occurring within this business. They don't want to count all of the tools and inventory that the business currently owns as an asset. They think that's just part of the business and it's separate. So it's really peeling back the layers of the onion as to exactly what's there and making sure that all of the beneficiaries are being treated fairly in those situations.
So would you say that your clientele is mostly people that have quite a bit of stuff to break up? Or is it people that they don't have not much to fight over? Not much to break down here because there's not much to fight over.
We run the whole gamut. I mean, we really like to think that we serve everybody. So, even if you feel that you don't have a lot, you should still have a will-based estate plan. Making sure you're putting the right person in place to be the executor, making sure assets are being distributed how you want. But also you need to have those power of attorney documents that are critical that while you're alive, if you lose capacity, we want to make sure that we've got a substitute financial decision maker and healthcare decision makers. Whether you have a lot or you have a little, you should still have an estate plan and one that could be updated every few years to make sure that you've got the right people in place. So I wouldn't say that we just focus on high net worth people or we just focus on farmers. I mean, it's the whole range of net worth.
I know that we talked about you doing some Medicare, Medicaid planning applications for folks as well. There is complications when it comes to filling out that application. And the one thing that I've heard is if you fill it out wrong the first time, it could take 4 months for them to get back to you. And then if there's an error, they send it back to you. So
Hmm.
let's talk about that a little bit as far as how that application works and why it's important that you get it right as far as what you do need to put and what you don't. Because I think that the application is a little bit vague when it comes to the questions. So maybe you put more than what you need to, or vice versa. What has been your experience with that?
Yeah, I mean, I certainly start from the point of view that you wouldn't think you'd have to hire an attorney to file a Medicaid application because it is a needs-based program. But I mean, quite frankly, the application is pretty complicated. The process is very complicated. I mean, our firm, we do a lot of applications. I mean, we effectively have a team lead, and we've got two Medicaid paralegals. I mean, all they do is file Medicaid applications for us. So I mean, on average, we probably do, maybe 10 a month or something like that. Making sure that you're disclosing exactly what they're asking for as opposed to potentially other things. But, you obviously want to be truthful and honest with what you're doing as well. Kind of the issue with the process is you are effectively targeting a Medicaid eligibility date. So you can only become eligible for Medicaid on the first of every month. And so you're targeting this date. So you have to get your assets spent below their required number. And then you file an application, let's say you're shooting for an 8/1 eligibility date. You're not going to file that application until you have all the correct documents, maybe the second week in that month. You file the application. DHS, takes quite a bit of time to review it, 4 or 5 weeks to review it. They always send a request for more information, an RFI. So then you collect that documentation and send it back. You're 2 or 3 months down the road before you figure out whether you were actually approved or not. And so if you haven't done the proper planning and gotten below those numbers and submitted all the correct information, you're 3, 4 months down the road. And if you're in a nursing home, that's a $30,000 or $40,000 proposition that maybe, you could have been eligible for Medicaid earlier if you had the correct advice.
So that is something that's actually really important. And in my journey to find the people that I want to connect with, which I do want to say that as I've been on this journey to find people and connect with people that are in the same space and passionate about taking care of our elders, everyone says they have, their estate attorney and their blah, blah, blah. I always ask everybody, who is the estate attorney that you go to? And every single person so far has been Matt Bollman. That's great for you that it seems to be that you're the consensus.
I appreciate the feedback.
Yes. So your workshop was not the only workshop that I went to. I think I told you that. I went to a few. And some of the feedback I had for some of the attorneys and the paralegals that came was there was a lot of negative talk about senior living communities, assisted living, all of them. And that's kind of the myth that I'm trying to break and the stigmas and all of the things that are associated with that. Part of it is, as I have evolved over all of the years in social work and in real estate, I've walked into some really bad situations where there's elderly people living very isolated, alone in houses that are falling apart, a lot of deferred maintenance, super inappropriate. I probably should have called DHS and had some elderly abuse. I have not, but it was bad. Mold, holes in subfloors, pills, expired food. I could go on at how horrible these situations are. And I think that the message that a senior community is a bad thing has got to stop. And the reason that is because I do think that these people that are sitting in these houses with all of the things that I just listed, they're lonely. They don't have anybody that's coming over and seeing them every day and checking on them. Maybe they have neighbors, maybe not. I don't know. But families are busy. And this isn't a dig at, young families, adult. I guess they're not really young. There's, the adult children are probably grandchildren at this point when they're in this situation. But they have jobs, they have husbands, they have grandchildren, they have soccer games, they have, their own life. Going over to their mom or dad's house every day, especially if they're by themselves, is not always possible. I think that we have to get rid of the stigma that moving into one of these places it's a bad thing, because it's not. We also have to get it out of the adult children and the family's mindset that the nest egg that's been built up, so the money that's in the house or wherever, is for them. It's not. I want people to be buying houses. Yes, I am in real estate and a realtor, so I always want people to buy houses. But buying a house now when you're young and having that paid off is kind of a guarantee that you're not going to have to rely on the government when it's time for someone to take care of you in that last chapter. To me, the thought of not having anything and having to rely on Medicaid, Medicare, elderly waiver forms, PACE program, all of those things that are out there and they're great. Having to rely on those and hoping that they're still there someday is scary to me. What are your thoughts on that as far as that stigma or how that the myth needs to be broken? Because I don't know if you've been to those places, but they're great. I mean, I like going in there because you see I love seeing the little old ladies meeting in the sun's, the screen porches with their coffee and their tea and just laughing and having a great time. The people that are sitting at home isolated because they think that aging in place is a better option, or, they promised dad that they wouldn't move mom into a senior community, but she's living in a horrible situation. It's not the answer. It's not what we should be letting our elderly have their last chapter as. What are your thoughts on all of that in regards to what should people my age be doing differently than some situations that you have seen where people didn't plan correctly?
Well, I mean, I break up from the legal perspective and for Medicaid qualification purposes, I break it into two different perspectives. So there's a proactive perspective where with Medicaid, there's a 5-year look back period on the transfer of assets. So you, in a proactive situation, pre-planning situation, you're getting the 5-year look back period started by transferring assets to an irrevocable trust. So that if and when at a later date you needed to qualify for Medicaid, as long as those assets had been in this trust for 5 years or longer, they would not be countable on a Medicaid application. So that's the proactive perspective. The crisis perspective, and most of the cases that we work on in the crisis situation is, it's the wife that's still at home. She just moved her husband to the nursing home, got her first bill for $10,000. What the heck do I do? We can reorganize income and assets to gain eligibility for the spouse still living at home. I mean, the house generally for Medicaid is an exempt asset. And so, you don't necessarily have to lose control of that or lose that asset in that crisis situation. So, I work on the legal piece of it, the financial piece of it. What you're referencing, I don't get into a whole lot other than safety is the critical piece of this. You've got to be living in a safe environment. And the idea that I've got to preserve this house or whatever for the kids when it is unsafe for you to be there, it's just not an acceptable situation. So, we do touch on that. But you're exactly correct that whether you have your parent at home or they're in assisted living or in a nursing home, the best way to ensure that they're receiving proper care is to go visit them and advocate for their benefit. And so, the more that you can be involved in your lives, the better care that they're going to get.
I would agree. I just don't think that it's always possible with how busy people are, right
Mm-hmm.
or wrong. I don't think that the amount of checking in that we need to do realistically does not match as far as what people have in their head. So checking in on mom and dad once a month is probably not a good situation if one of the parents has Alzheimer's or, they're bedbound or, one parent is doing all of the caretaking. That's another thing that I see often is if one of the spouses has Alzheimer's and you have the other spouse that's doing all of the caretaking, generally speaking, that other spouse was not in the industry of caretaking. And they're taking on so much stress. They're taking on so much extra work that they are no longer living their best life either because they are having to do everything to take care of their spouse. And I'm finding that it's really a disaster because neither one of them are having quality life. And I guess my mission is how do we preserve that last chapter and having quality of life? Why do we have to make it sound like it's, the last chapter is the worst when it doesn't have to be? And I think it's getting the stigma out of there that you have to leave a nest egg or you have to leave an inheritance for your children when you really don't have to. And let's be honest, it's a different world than it was in 1980 when it was easier and cheaper and you could do that than now. It's expensive to live now, period. And I hate calling them, there is a nursing home and that would be a facility, right? Because there's like the medical, there's nursing all the time. However, it's not all the same anymore. We can call it housing for the independent living and even the much lesser. There's a lot of spaces here in Des Moines that don't even have nursing staff there. So it's just housing, but you have people checking on you. You have your meals, you have all of these things. What are options that people can do and prepare now at my age and even at 55 between long-term living? There's like insurance, right? What are those called? Like
I
long-term
mean,
insurance.
obviously,
Yeah.
long-term care insurance.
There's also some benefits with VA. Is that correct?
Yep.
There's annuities.
Yeah, I mean, I look at the options to private pay would be purchasing long-term care insurance. So that's working with your insurance or financial advisor, insurance professional or financial advisor to talk about literally just the pure long-term care insurance. So, you're purchasing insurance is covering the very risk that you're concerned about. There's also a lot of options as far as riders on annuity products or life insurance products that have a lot of flexibility within those that can pay for benefits for care at home, assisted living, nursing home care. So, we always advise people, seek those options out. I mean, it's nothing that we do. The issue for us is usually when people are coming to visit with us, age-wise, it just doesn't make financial sense anymore, or health-wise, that can't be underwritten on some of those products. And so then people are looking at private paying, which, is certainly an option and something that should be seriously considered. But people look to us to get them eligible for Medicaid, qualify for a VA pension. So we won't want to put everything out there and making sure that you're getting the best care that you can.
Sure. Okay, so back to the wills and the trust. What is some of the most interesting things that you've seen families put in wills? I know that you have to be vague about this, but have you seen things that make you have a double take on what they just said? Or what are things that wouldn't be, and I want to put this out there for people to know that they can come to you and they can be comfortable having this conversation, that there's probably, you've heard it all. You've probably heard it all, right? So what are some of the most fun or interesting stories that you can tell us about that we wouldn't expect?
Well, I mean, when I talk to people about designing estate plans, I mean, we want to make sure it's as clear as possible so that at the point you pass away, there's not going to be a big dispute over what you put into that document. So clarity is a big thing. Another thing that potentially causes issues is, we're going to treat beneficiaries differently. The often used situation is you've got, a farming family and one of the kids stayed back to farm. Two of them moved off the farm. We're land rich, we're cash poor. And so mom and dad pass away and we're going to give a big discount to the on-farm heir as to either getting all of the farmland or, being able to buy it at a much reduced rate. And so some of those things can get pretty dicey in those situations. Whether you do a will with us or you do a trust with us, we also include a personal property memorandum. So you, over time, can put down on this document where you want your couch or TV or chair or vehicle to go so that you don't have to go visit with an attorney every time you want to change that. So, I mean, it's probably the personal property that is the most unique stuff as far as distribution. I mean, the rest of it, we try and keep as much clarity as we can so that things will actually work out the way that you want them to work out.
Can you name something that's been interesting that you've come across, or
Well, I can tell
news
you
that you've had to deliver?
Something recently that wasn't in the will but was in the estate was this person had visited an Indian, I believe it was like an Indian reservation, and there was some type of exhibit or museum there, and they had actually stolen something from the museum. So there was this Indian artifact that we then had to have returned, and the Indian tribe was very thankful that the executor came upon this, identified that it wasn't owned by the decedent, and we actually were able to get that returned to the proper people. So yes, you run into things like that all the time.
That is awkward for everybody, but hilarious at the same time. But that there's a generation, I feel like it's still, they just do what they want. Fair enough. Okay, so what has been some of the biggest family fights? So there's two parts to this question. I want to know what some of the biggest family fights are, but on the other side, do we wait to tell family some things until after both parents are gone? So then you get to be the deliverer of the information. You get to be the message man on what's actually in that will. And, mom and dad are long gone, so they don't have to deal with the blow up.
Well, I mean, especially when people are doing trust-based estate planning. I mean, I talk to people about trust as I look at it as you are organizing things today to make it easier and less expensive to administer. So the more information that you can get out to your family members to make sure that their expectations are being met and their curiosities are not driving them crazy, I think is beneficial. So we would probably recommend that. But, especially with the older generation, they don't have a lot of comfort level. They're much more private people than maybe my generation is. So, if you do, it's just your own level of comfort as to what you want to explain. But certainly, the people that you place in the role of financial agent or healthcare agent, you want them to know that they're in those roles. You want to make sure that they have access to those documents in the event that you lose capacity. You pass away, you want your person, the trustee or the executor, to know where those estate planning documents are at so that they can access them and it's not some big surprise and we've got to go to court to be able to get to them. So there's got to be some education along the way. Absolutely. And then there was a follow-up question. Yeah, sorry, go ahead.
I think that you've hit on this a few times, but can you share a time where someone just did all of the right things and it just made a huge difference? Like it just made everything much more simple. The family dynamic didn't dissolve, there weren't fights.
Yeah, I mean, well, with a properly set up will plan or a properly set up trust plan, you've got the right person in that role to do the administration. I mean, these things should go pretty smoothly. So, both processes, probate and trust administration, work just fine. It's just one is going through the court system, the other one isn't. But when you can do a bunch of pre-planning and have things set up correctly, everybody's understanding what's going on, and then you've got that person in charge that's providing transparency to the beneficiaries, everything works great. When you don't, things go sideways all day, every day.
Do you feel like you've ever had to play mediator in that role as far as what that looks like and taking phone calls from, angry kids and they're all grief stricken. So they've just lost both of their parents. They have to figure all of this out, but there's obviously conflict. How do you handle that part?
So we talk to our clients about, who are you going to put in this role of executor? Who are you going to put in this role of trustee? Oftentimes people are like, well, let's just put all the kids. And I think that's just a horrible idea, because then you've got multiple decision makers and, are we doing it by majority decision making? Is it going to require unanimous decision making? So, where you have multiple decision makers, I think introduces an element of potentially more conflict. I mean, I remember and mom and dad did trust planning really late in life, trying to make sure they were setting things up to avoid probate. And so it was kind of a rush to get done before both of them passed away. And then both of the sons were named as successor trustees. And I mean, literally those two could not agree on the color of the sky. So, the idea that mom and dad named these two kids who just couldn't get along about any, if I would have known that, I obviously would have advised not to do that and potentially name a bank trust department so that we can at least get through the administration process would have been helpful. So obviously the more information that the client can bring to that estate planning design meeting so that the attorney can provide some suggestions as to who to name and why would be super helpful as well.
Maybe some people want to do that with the purpose of knowing, like, we're not going to be here and these two kids have been fighting their whole life and we're not going to let them stop now. So
that may be the case, but I know in that particular situation, each of them hired their own attorney and, the bills ended up being pretty substantial in that situation.
right. I mean, after you do that and you get your own attorney, now all of a sudden you're just burning the money. I mean, right or wrong, it seems like ultimately what happens, and that happens a lot in all spaces. I do have a situation. I have a realtor that's on my team, and she's handling some estate stuff right now. And she has exactly what you have going on right now, an estate that there's too many people in charge. And she gets calls from all of them and suggestions from all of them. Some of them want to list at this price, and some of them just want to get rid of it because they need the money and they just want it gone. And she gets it from all different directions, which makes it hard for her. But in that situation, I think that's exactly what we're talking about. There's too many chefs in the kitchen and too many opinions. And we just have to have one person calling the shots at this point.
Yep. And again, if you're choosing somebody that can operate without conflicts of interest and, obviously have the beneficial interest of each of the beneficiaries in mind, that's possible. If you don't have somebody like that in your family, then, let's consider naming a bank trust department because they will operate it very efficiently.
What are some of the misunderstandings that you think that children have most about their parents' wishes? So when it comes to maybe where things get lost when we're talking about money, I think no matter what, the wishes get lost in all circumstances when money gets involved. Money will make anybody fight. What do you think that the misunderstanding is when it comes to parents, their wish,
Yeah.
what they want?
I mean, I think there can be a couple things there. I mean, one is oftentimes the beneficiaries think that there were far more assets there than maybe were actually there. And so that's one thing. I mean, they're searching for, I thought there was a lot more. And it's like, well, it is what it is at this point. And so that's one piece. The other is, maybe if mom or dad had been promising them something just verbally, but then the estate planning document shows up and that promise is not in the document. Well, we're going with what the document says or doesn't say, not with what was supposedly promised during life. Obviously, parents are trying to keep their kids' attention and make sure that relationship is going well, and sometimes that stuff does happen. It just doesn't end up in the estate planning document.
Which is too bad. But, again, I think sometimes parents may not want to have hard conversations with their kids. So
Exactly.
they just wait it out. I mean, what are they going to do after? So as far as age, a lot of the stuff that I see recently, I went to a showing for something on annuities and it was directed at 55 plus. And I thought that that was interesting because I don't think that people need to be waiting until 50, 55 plus to be having conversations with you or anybody to be getting these things in order, to be getting their retirement in order, to be getting their long-term care, solely because then we're almost in crisis mode. So when we're talking about that, what do you think is the appropriate age? And of course, you could say 18. That's obviously not realistic. Nobody even has any money at that time. But when is the appropriate time for someone to come in and say, I want to start getting things in order, completely healthy? Is it when they start a family? Is it when they get married? When is the time that someone can come to you and make good decisions?
Yeah, I mean, just generally, I mean, I would characterize as, everybody probably should have an estate plan. I mean, even somebody that just turned 18, if you lose capacity, if you're unable to make healthcare decisions, unable to make financial decisions, and you do not have power of attorney documents, your parents or other loved ones will have to put in place a guardianship conservatorship. Power of attorney documents are very inexpensive to set up. Say that everybody should certainly be getting power of attorney documents. But normally, people that come visit with us are, we just got married, we just had our first child. If something happens to mom and dad in that situation, we don't want those assets going outright to that beneficiary. We want to make sure that we're putting the right guardian in place. And so usually the first people or the first time people come and visit with us was when they have a family, have that first child. We visit with the attorney, probably going to set up will-based estate plans that would create a trust in the event both husband and wife have passed. We're going to create a trust for the benefit of the children.
So I just want to clarify this. The most ideal time to come in would be when you're 18 and you're off your parents, right? Naturally, if you don't, something happens to you and you're in the hospital in a coma, it's going to default to your parents most of the time, correct? Unless you're married?
It
No.
won't default. I mean, that's the issue. That's why we would want to have the power of attorney documents in place.
So who would it default to if someone that was, an 18-year-old boy that got in a car accident and he was in a coma, who would it default to if that wasn't in place?
It defaults to nobody. And so that's when mom and dad would have to go get a guardianship conservatorship proceeding going.
That's kind of scary. I suppose it defaults to the doctor making medical decisions at that point.
Well, they're
I mean,
certainly going to, they're going to defer to family members standing around the waiting room, but ultimately, financial institutions are going to require mom and dad to go get a conservatorship to be able to manage finances.
and how long would that take? How long would it take if there was a crisis for
You
them
can
to
do
do
an
that?
You can do an emergency guardianship conservatorship proceeding. We're talking a couple weeks, but it's a month to 2 months to get an official final guardianship conservatorship opened up.
Well, in a trauma situation, that wouldn't 1 to 2 months would not be of any help at all. So, as a relationship, or I suppose as a client based relationship with you, the ideal person comes in when they're 18 to establish that. However, once they've gotten married and they are now having babies, I feel like this is kind of a revolving or a long term relationship with someone like you because life is always changing. If you have mom and dad as your power of attorney and then you get married, it's probably now your spouse. However, is there ways to have two? I'm sure you'd have your spouse, but if you were in an accident with that person, then it would go to your parents, correct?
Yeah, I mean, you usually do at least 2 layers deep. Yeah.
Okay. So to me, it sounds like someone should just have an open relationship with you. So then you're able to be there along all of the way as life changes. You get more assets, you have more children. Is that correct? Is that something Is it
Yeah, I
something
mean,
that should happen? Is it something you see happen?
it is. Yeah, I mean, kind of the natural progression is, hey, you turn age 18, let's make sure we have POAs in place. Probably going to do a simple will. You get married, then we're usually doing wills that would create a trust in the event that something happens to both husband and wife. Then once the kids maybe move out of the house or close to moving out of the house, that's when we look at doing revocable trust-based estate planning. To make sure that we avoid that probate process and reduce administration costs. And then, you're much later in life and you got this idea of asset protection against long-term care costs, you might do an irrevocable trust really late in life. So, I mean, with every major life event change, you probably want to go visit with your estate planning attorney. If there haven't been any major life changes, you probably still want to visit with them every 5 years just to review documents and see if Congress changed anything or anything like that.
Have you ever had a situation where you've had someone as a longstanding client or not, and they come in and you can just tell that they're not of complete, they're not complete sound mind?
Mm-hmm.
What do you do in that situation when they come in and they're telling you this is how they want things, and you just know that they probably shouldn't be making these decisions? What do you do?
Yeah,
We'll
so
call
I
this
mean,
crisis mode. Would you call this crisis mode?
well, potentially, but I mean, if we're literally just talking about identifying that they no longer have the ability to make decisions, and maybe that's a little touch and go. I mean, certainly if we're questioning their capacity, I would oftentimes send them back to their doctor and say, hey, can you get a physician statement saying that you have capacity to make financial decisions? If they bring that back, it provides me a little more assurance that they can. But people have good days and bad days as well. And then if we're to the point that there is not capacity or it's very clear, obviously we want to make sure that the substitute decision makers are notified and they're being brought into place to be able to operate for them.
After someone has that onset of Alzheimer's, that's kind of the point of which they're no longer of sound mind. And that what they would say or wish at that point, if it was different than prior to, what do you do in that situation? So if they've come in and they have a will or they have a trust in place, and then they come into you and you can tell they're repeating things. It's very clear that they're just not of sound mind. What do you do at that point?
Yeah, I mean, their estate planning documents are not changing at that point.
Okay. So don't come in at that point. That is not the time to come in and start planning these things.
Correct.
What is the situation that you do if you have a husband who's perfectly fine, very sharp, but he brings his wife in and she's not? And I'm asking this because a lot of the situations that I come across, families are in denial and they don't want to acknowledge this. There have been times that I have had some elderly families selling houses, and I can tell that the amount of times that I have to repeat things in the same conversation. I get that we are all experts in our industry, and I repeat things all the time for first-time homebuyers. I repeat things all the time for people, and that's normal. But there is conversations that I have, and I can tell that we're repeating within the same 5 minutes. And I'll say something to the kids like, hey, I'm just noticing this, or a situation where the elderly kind of goes unhinged when the sun goes down. And I think that we call that sundowners. And I'll mention it to the kids, and they're like, nah, no, that she's good. She's fine. She can make all of her decisions. That's just how mom is. But and I struggle in those cases sometimes. Has that ever happened to you where you were like, no, I know, but they're all in denial. I can tell something is off here.
Yep. I mean, in those situations, I will send them back to their physician to document the issues. Obviously, that physician can educate the family as well. And then, I mean, there are people in the community that do kind of just educational pieces to try and educate family members as to whether mom in her current condition has everything in the home to be able to be safe in the home. Do we have the grab rails and things like that? So there are people in the community that you can put them in contact with as well.
The reason that I'm asking this, and I think it's important, is I don't think that people should be waiting until crisis mode. And there are identifying factors and how much harder it becomes when we do wait until we're in crisis mode, or we're like, oh no, I don't think mom and dad have updated their will in 25 years. We need to get them in because something's wrong with mom. So the message that I really want to get out there is crisis mode is not when we need to make big decisions. All of these are big decisions.
Yeah, and I mean, there's a couple factors there. I mean, one is that sometimes people just have this natural procrastination piece of it. I mean, the other is that, things that we don't want to deal with there's anxiety associated with, going into a law office and talking about these issues. And I totally understand that. I mean, I would like to think that, all the attorneys at the firm are pretty open and honest brokers about situations and, providing good recommendations. We have comfortable offices for people to come in to. And, our office in West Des Moines is on the first floor and very accessible to everybody. So we just try and create a comforting environment, knowing that we're talking about difficult.
So I talked to Chad in your office as well. Both of you guys have been fantastic. One of the things that he had mentioned was he agrees that we're leaving seniors in their houses probably a little bit too long in some places. He had said, and I'll let him speak on this too if I ever can get him on here, but there was a situation where his grandma was in her house and she accidentally left the gas stove on and it was just, the gas coming out. And I think that those are kind of the final, straws. But these are huge safety issues that I think people are just kind of missing or just chalking up as an accident, but are huge, large problems that we're too far past at that point. If those things are happening, we're too far past of when we need to be. And I would consider that crisis mode. Is that what you would consider crisis mode on all spaces too?
Yeah, I mean, if you're about to blow the house up or burn it down, then yes, we're definitely in crisis mode. And,
Right.
I mean, obviously everybody can be forgetful and have a little accident, but, you're particularly vulnerable as we age in place. And so being at home might not be the best place for you at that time.
Right. Or coming into your office.
Correct.
What do you think is the biggest misunderstanding that people have about inheritance? I asked that from the space of and I apologize for interrupting you, but as far as people thinking, adult children thinking that they're owed something, what do you want to tell the public?
Well, I mean, obviously being a beneficiary in a will is sort of it's a privilege and it's a gift. That parents are trying to provide to you. Kind of some of the issues we see is people think that this is going to happen overnight, and it does not. Regardless of whether we're going through probate or whether we're going through trust administration, moving assets from the date of death ultimately to the point of distribution is months, if not, a year-long or longer process. And so this expectation that we're just going to, mom and dad passed away, a week later, we're going to get things, does not happen. There potentially can be partial distributions through the process, but I certainly wouldn't, as a beneficiary, have that expectation. We work as the estate attorney as hard as we can to make sure that the beneficiaries are being provided transparency as to what's going on. You want to make sure that executor or trustee is creating a good inventory, basically a date of death valuation of the assets, and then that there's an accounting, basically documenting every transaction that occurs in the process. And they have a right to that information. Kind of the other kind of misconception is how taxes work. So sometimes people think that there's lots of taxes associated with inheritances. I mean, effectively, there isn't. Currently, the federal estate tax exemption is right around $14 million per person. So not many people have federal estate tax issues. Usually assets are going to lineal descendants. Iowa, I believe we're in the last year of eliminating our inheritance tax. So after this year, if you've got assets going to a sibling or a niece or nephew, there won't be any inheritance taxes either. So really the only tax issues are things growing tax deferred, like a government bond or an annuity, or where taxes have not been paid on the money like a traditional IRA. Everything else generally gets a step up in basis. The beneficiaries get the date of death value of that asset, eliminating the capital gains. So those are just a few things that I think are misconceptions about the process.
I want to go back to the actual farm one because I think that's a big one. We talked about that a little bit ago. So let's say in this scenario, we have a farm family and we've got one brother and two sisters. And obviously, I think it's natural that the one son stays and takes on the farm for dad and the family. I wouldn't say he's renting it, but he's caring for it. That's his means of income. And now all of a sudden, both of the parents pass away. Now generally speaking, it would be like the brother has to buy the farm off of the two sisters, right? Their chunks. Is that usually how that works?
Well, I mean, there's a couple things there. I mean, one is that certainly the on-farm heir can purchase the other two out, but oftentimes, certainly at current per acre rates, that can be a significant sum of money. Kind of the alternative is that the on-farm heir can rent the land from the other two siblings.
Okay, that's my question is how does that usually, because we don't want to take away, we don't want to have to sell his job, sell to pay the sisters off. So usually how you see that happen is that he just has to pay them monthly rent for their portion.
Yeah, I mean, when people do leases, I mean, a farm lease, usually the payment's twice a year, but you could organize it however you wanted to. And you're either just cash renting it or you're sharecropping it, where you're basically business partners in that situation. So there's many ways to do it, but it's working through all those situations or solutions so that everybody is kind of educated in the process, so that they know their options, because there's unlimited options as to how to make sure that it works out fairly and keep the family keep the farm in the family. I mean, usually that's the ultimate goal there.
Or any business. I mean, I'm using farming because I think it's the easiest, but that would be any business that there's only one child involved and the other two are not.
Correct.
And when that doesn't get clarified with lots of clarity, that's when the disaster comes, right?
That's when the disaster certainly begins. The other is creating expectations, making sure that everybody is on the same page. That on-farm heir shouldn't think that they're somehow entitled to the entire farm just because they've been farming it, and making sure that that's clear to everybody. Or if that is the goal of mom and dad, making sure that that's being explained maybe to the other siblings so that it isn't some shock and awe at the point mom and dad pass away.
That's my next question. Have you ever had to tell someone that they're not in the will, and how does that go?
Well, so we certainly don't do kind of the reading of the will that they, portray in movies and things like that. But absolutely, we've had to have hard conversations about how somebody's has been disinherited, and those.
Disinherited, that's a rough way to put it.
It is a rough way to put it.
I suppose there have to be clues up to that point for someone to know that they're probably not in the will. It can't be a complete shock.
Well, part of our practice areas is we do some litigation related to, for example, will set aside cases, where maybe one example here would be, one of the kids took mom to an attorney, or maybe they did an online will and drafted the will themselves and included themselves as the only beneficiary. So when the other siblings get this will at the point mom passes, it is an absolute surprise that they were disinherited. And that happens more than you think it should. Say that again?
What happens at that point? Do the other siblings sue? Is there a way to work that out? Does everything get held up in the court?
In that situation, yeah. Usually the beneficiaries that have been disinherited will hire an attorney to file a will set-aside case. Usually those cases are brought on the grounds of mom not having capacity, or undue influence, or tortious interference with an inheritance, those types of things. That would be the cause to have that will set aside.
So let's talk about the other real estate. You mentioned earlier that the family home, if someone's living in it, if the spouses decide that dad has Alzheimer's, he needs to go to a space where there's people to help care for his medical needs, his memory, maybe like a memory care unit, and mom wants to stay home. The house is exempt. Let's touch on that a little bit more in regards to, are there other things? Is that a time that if the house is exempt and mom wants to stay home, but there's not other assets, is that when someone would need to come to you to start that Medicaid application or the Medicare or elderly waiver?
Yeah, I mean, let's use the example that the wife is still living at home and the husband took a fall and moved into a nursing home. I mean, in that situation, DHS, Department of Human Services, will effectively take a snapshot of their assets. They will break the assets out by husband, by wife, countable, non-countable, and then in the corner of that worksheet, they will tell you what you have to spend down to gain eligibility. Just generally, the non-countable assets would be the house, one vehicle, prepaid funeral plans, personal belongings. Everything else will be countable. So in that situation, we would work with the wife to document this. We would advise her that, to gain eligibility, your husband's going to have less than $2,000 in assets. So that's, working to get his assets transferred just to her name. And then DHS is going to require that she be spent below a certain number. I mean, ballpark, that number is the lesser of $158,000 or one half of your countable assets. I was just working with a husband wife yesterday. They've got $200,000 in countable assets. So her spend down number is going to be $100,000. And so we would advise her on, let's, get him moved into a facility, or he's already there. We know we've got to spend down this $100,000. How are you going to do it to best preserve the assets for you? So we would focus on paying down debt if they have any, purchasing exempt assets. Let's say they've got a really old car. Well, let's trade that in and buy a newer car because that's exempt, or deferred maintenance on the house. And then lastly, there's a very specialized financial product called a Medicaid compliant annuity, which allows that spouse still living at home to take a chunk of countable assets, put it into this annuity, and DHS no longer looks at it as an asset. They look at it as income back to her. So effectively, in the husband-wife situation, we really can preserve all of those assets for the spouse still living at home. The whole goal is so that the spouse at home doesn't impoverish themselves spending all of the assets on the spouse that just moved to the care facility. So, those are the most rewarding cases for me, because that person still at home has an incredible amount of stress about, I'm facing this $10,000, $11,000, $12,000 bill a month. Where's that money going to come from? We can very quickly make that bill go away by gaining Medicaid eligibility, still preserving the assets for them at home.
So what I understand, and that was my next question, was if this were to happen and there has to be, they can only make so much a month, or they can only have so much and spend down, is that going to lessen what they're getting for income? Because the, DHS, and they're watching, because what private pay is not paying for, the government's paying for. So are they keeping an eye on that? So it is kind of complicated what you just said. And that's honestly, I don't think that it's our job as the public to try to figure it out. And that's why we have you as an expert in that space. And for you to explain it for it to make sense to us would be unreasonable. So I guess my question is, if that happens, I think the fear is you're going to be without a house. You're not going to have any money. You're not going to have any income. All of those things. And it doesn't sound like that's what's going to happen.
Correct.
Matter of fact, Grandma might get a new car.
Well, you need to advocate for yourself, because, if you don't do anything, certainly, the way things operate is that you potentially could lose all of your assets by private paying, or then be forced to sell your home and then continue to private pay. So if you do not tap into these benefits, then yes, you could lose everything. People come visit with us. We will walk you through what we would advise. You don't have to do it, but at least we've educated you on an alternative option, and then you're the one choosing whether you want to do that or not.
Over the last 3 years that I really started taking on senior citizens as heavy clientele in real estate, one of the situations that I had was Grandpa did have to go to the nursing home. It was more like it was memory care, and I hate calling that a nursing home because it didn't feel like that. It was housing, a place that he was safe, right? Housing that he's safe.
Exactly. Yes.
And they were worried. Grandma did not want to not be with Grandpa. She wanted to be in the same space, but she just needed to get some stuff squared away before. And I believe at the time that they did come to the solution that with that spend down, the family and her were going to do some things to make the house more marketable, fix up some deferred maintenance stuff. And then that's when they were going to sell and then use that money for the private pay so then she could be with him. And that is one way that you just said would be counted as the spend down, correct?
Mm-hmm.
So that would be a way to be able to get more on the back end of selling the house.
In that situation, we probably, and again, not knowing all the details, but, we probably would have recommended, let's gain eligibility for dad right away, because once he's eligible, they're no longer looking at the wife's assets. And so then she could sell the home, create more liquidity for herself that could be used to private pay for her in that independent living situation.
What is and this is kind of changing directions a little bit, what is a mistake that you wish people would stop? Something that we just don't know that's a huge mistake that's making or breaking or a huge difference in all. What is that mistake that you want people to know right now?
I would say the biggest mistake I see, it's a misconception by me. I don't understand why banks allow people to do this so easily. It would be adding your children on as joint owners on your account. For some reason, the person thinks that, well, if I lose capacity, I want to make sure this person quickly has access to that account, or I pass away, I want to make sure they have money right away. The downsides of it, though, outweigh those concerns. One, you should have a financial power of attorney in place so that if you lose capacity, you've got your substitute financial decision maker. So you don't have to add that person on as a joint owner. The other is, what if that person that you added to your account gets a divorce? You're going to lose that asset to their, your ex-in-law. What if that person gets into a car accident, they're being sued? Or what if they predecease you? Then you have nobody to act in that role, and then you're forced to put in place a guardianship conservatorship. The other is that joint owner, if you pass away, you've put one of your kids on as joint owners, that account is now just their account. They have zero obligation to split that with their other siblings. And oftentimes they don't. And so I would say adding people on as joint owners for this supposed convenience sake is the biggest mistake I see.
One of the workshops that I went to, it was not yours. That was the exact situation. However, mom had her daughter-in-law on the account. And when she passed away, daughter-in-law had access to the whole account, and all of the siblings, I don't know, he didn't mention whether, daughter-in-law's husband, the son, was one of them suing her, but the daughter-in-law was getting sued for all that because someone told her, that's your account, have fun. And I don't think that was the other siblings' plan. I don't even know if that was the mom's plan. There wasn't more to the story on base, why didn't one of the kids? Maybe she had all sons and she had one of the daughter-in-laws, doing it. I don't know, but that was a situation that everything was held up. Obviously, lots of money go to lawyers at that point with everybody fighting over where that money is going. But that was the exact situation you just said, and it did not end well.
Well, and I would imagine the daughter-in-law will probably win because she was the joint owner.
And my fight would be I was the one taking care of her. I was the one doing all of the errands for her. That would have been my fight. Clearly, she trusted me.
That would be an uphill battle for you to win on that.
As the daughter-in-law, you said that I would win.
No, the daughter-in-law.
Yeah. And that would be my fight is, she trusted me to take care of her. So,
well, you don't even have to have a supporting reason for it.
Right. Oh, wow. Really?
Really?
Wow. Okay. So when people walk into your office, they're probably a little bit nervous. They don't want to talk about these things. They don't want to talk about the end. What do you feel like when they're leaving? Do you feel like they're almost breathing?
Mm-hmm. Yeah, I mean, we have this tagline. I don't think it's unique to us, but it's the, we plan for everything you own, everything you love. We want to provide you peace of mind. I mean, I can't tell you how many people, as I shake their hands on the way out of my office, leave with this, you've given us some peace of mind that things are going to work out the way they should. And so that's rewarding.
Right. Absolutely. I think that having the conversation is intimidating, but walking away from it is probably such a relief knowing that it's just done. It's done. There's nobody here judging me. There's nobody here that's, has any interest in this. They are literally a third party helping me do what's best for what they think is best for them, their assets, their money, their family, their legacy. I think legacy is a big one on that. And also, like we've talked about their last chapter. What have you learned from working with this crowd or working for your own life? What has it taught you about life?
Well, just operating in this space, operating in this practice area with the people that I do. I mean, it certainly has made me a more patient person than maybe I have been naturally. The other is a piece of empathy. I do enjoy visiting with people. I do enjoy understanding their story. My old partner, Phyllis Pearson, always used to talk about how, you can come in and you can tell me your whole story. I'll sit there and listen to it. And we oftentimes do. I had a woman in yesterday that was from Australia and went to school in London, and then her husband had transferred to someplace in North Dakota and ended up in Des Moines, and she's still working very late in life, and she just had a very interesting life story. And so, my passion is being able to meet new people and to hear their story and ultimately make sure that, in the event of incapacity, in the event of death, that we've got some documents that are going to support their decisions.
I love that. It says more that it's more than just a transaction to you. You really care about the people that walk into your office to make sure that all of these things are in place and that things are going to be left like they want them to. What is one thing that you wish every listener would do this weekend or next week? It's Friday. Next week for a peace of mind. What is the one thing that you would want everybody to know and do?
Yeah, and I talk about this in my workshop quite a bit. I mean, I believe I bring it up in every workshop. If you don't have estate planning documents, please go visit with an attorney and get them. The other is if you do have them, dust off that estate planning binder. I mean, it isn't something that should sit in the closet or the safe for 30 years. I mean, it's something that you should pull out every so often and just double check that you have the financial power of attorney, healthcare power of attorney, and living will. It is really surprising to me how many people I visit with, they've done all the right things. I mean, they visited with an attorney, whether they specialize in estate planning or not, I don't know, but they're missing one of the power of attorney documents. And so just double check that you have both the financial and healthcare power of attorney.
And those change, like we've talked about. You have to stay up to date on those because it's ever evolving.
Exactly.
How do you recommend that families bring these topics up with their parents? Like, hey, we haven't gone in and done this for a while. Do you have something that you've seen that's worked better or not? Or is it an invitation to one of your workshops? Because that might be a good, let's go check this guy out and see what he has to say.
Well, I'm glad you brought that up as a good suggestion because I don't know that I had a good answer, but I would agree. It's easiest probably brought up when the conversation is coming with maybe a third party involved, because it is difficult to talk to mom and dad about, and you don't have to talk about, hey, mom and dad, how are you going to distribute your assets? I mean, it really is, mom and dad, let's make sure that in the event of your incapacity, in the event of your passing, that we've got the right people in place and that the right people know where those documents are at so that we can access them. So it's kind of focusing on the safety piece and the advocacy piece rather than where the asset's ultimately going to go.
I feel like one thing that I struggle with when I'm making big decisions like this is I want to do business and I want to have people in my circle that I can trust, that are likable and that you just mesh with. And that is really the reason that I think that the workshops and having intro things that people can come to, meet you, hear how you talk, hear how you approach things. It's really important because the idea that you're calling someone, committing to paying, and you have a free consult, which is great because a lot of times lawyers don't have that free consult. And the idea that you're having to pay $300 an hour to go in and just meet someone that you don't even know if you're going to click is intimidating. It's intimidating. The same thing if you're going to go start visiting senior care communities, if you're going to have any kind of annuity talk, anything that has an expert involved, if you don't click with that person, they come off too salesy. They come off as they're driving the ship and not leaving. They don't really care about you. I think that that's important to make sure that you give people the opportunity to hear from you and to see you and before they make a commitment to you. So I think that that's what's great, that those workshops are available. You have them all over Iowa and anybody can come. It does not cost to come.
I mean, in addition to the workshops, I mean, I believe that we've developed a team of attorneys that operate in our goal is to educate you on the correct estate plan, or not correct estate plan. We're trying to educate you on your options. You are choosing the one that is right for your situation and your family. And if that requires one free initial consultation or two or three, I think all of the attorneys are willing to put that time in to make sure that you make the right decision for your situation. We operate in my opinion, a very stress-free environment. We're not putting pressure on you as to making decisions and things like that. So, our big piece is making sure that you're being educated on what you're doing.
I just want to go over again where your offices are. So if you could say that again, just so we can have that on repeat so everyone knows where you guys are located.
Yep. So we've got an office in West Des Moines, and that's where the practice really started. We've got one in Cedar Rapids, Dubuque, Bettendorf. We've got an office in Okoboji. Our newest office, we just opened up an office last year in Overland Park, Kansas.
And if someone wants to find out where or when your workshops are, where do they go?
Yep. They can go to our website, and we've got our seminar locations or workshop locations on there. And that's PearsonBollmanLaw.com.
Perfect. And how many attorneys do you have in your office?
There's currently 6 attorneys.
Okay. And you guys are just focused on elderly law, estates, trust, wills. That is what you guys do.
Yep. We do estate planning. So that's wills, trust, power of attorneys. We do probate trust administration, advising executor, advising successor trustee. We do elder law. Oftentimes that's supplemental needs trust, special needs trust, the Medicaid planning. We do litigation related to those areas.
Thank you so much for coming on. I really do appreciate it. I appreciate your time. This has been super helpful. And while I said I didn't want to get into the weeds of all of it because it's far too complicated for all of us to even try to understand, and that's why you have a degree, this has been super helpful. And I hope the message that we're sending out is people just need to prepare. They need to get in contact with you or any estate attorney to be able to get their ducks in a row.
Well, thank
Yeah.
you for having me.
You're welcome. That's